Hi everyone, thank you for joining our webinar today, which is looking at social media in recruitment and employment. My name is Laura Warnacott. I'm an associate in the employment and immigration team at Ashford, and today I'm joined by my colleague Hannah Elliott, who's another associate in the commercial and data protection team. And today we're going to be speaking about three core issues. So firstly, the use of social media within recruitment, what the benefits might be, and also the risks to look out for. Hannah's then going to cover data protection compliance when using social media during the recruitment process. And finally, I'll be looking at social media within employment processes. The hugely increased use of social media in everyday life has not bypassed the world of recruitment and employment. And more than ever, employers are using social media in their recruitment processes in a range of different ways. That might be from engaging in external recruiters who will search on social media for candidates, or using specialist software to highlight chosen criteria or red flags, or simply by Googling or searching for a candidate's name on social media or in a search engine. Indeed, in some sectors, such as education, online searches in the recruitment process are encouraged in statutory guidance. So social media is being used all the time in recruitment, but should we be relying on it, and what potential risks are there in doing so? Let's have a look at that now. Before we look at the risks, though, we'll first explore the potential benefits of using social media as a tool in the recruitment process. It's reported that around 90% of recruiters use LinkedIn for social media recruiting, and a platform like LinkedIn, designed specifically for professional use, can arguably give recruiters and employers more of an insight into a candidate in relation to their published work, their experience, and their practice. Social media platforms and software that can scan online sources claim to make recruitment and selection processes more efficient. The aim of these tools, it's claimed, is to gather more data about an applicant's competencies and personality traits to ensure that the employer is hiring the right candidates. This software can scan platforms including Facebook, Instagram, and X, formerly Twitter, for specific content that could raise any red flags, such as illegal activity, discriminatory views, or other problematic behaviour. Nevertheless, these methods are controversial since they can lead to different legal and ethical issues, such as discrimination and an invasion of privacy. Additionally, some problems may arise regarding the validity and the fairness of information found on such platforms. We're also aware from feedback from clients that have had experience of using recruitment software which searches for candidates that the information gathered wasn't actually very useful at all, and created a huge burden on their recruitment teams in sifting through all of the results. For example, one of the things that was raised was that the results would flag up drink and drug use for candidates who were simply pictured on their Facebook profile with an alcoholic beverage in their hands. That created a huge burden on the recruitment team, having to sift through all these supposed red flags. So we've had a look at the potential benefits and the claimed benefits to using social media in recruitment. Now, it's not a coincidence that the list of risks on this slide is longer than the list of benefits on the previous. Probably the biggest risks in relying on social media searches in a recruitment process is that you could be opening up the organisation to the risk of discrimination claims. Searching for a candidate on social media may reveal protected characteristics that you wouldn't have been aware of from an application form, a CV, or an interview. The protected characteristics under the Equality Act are listed for you on the slide here and are race, religion and belief, sex, sexual orientation, marital status, age, disability, gender reassignment, and pregnancy and maternity. This was the case in the discrimination claim against Touchstone, which is referenced on the slide. The candidate's references weren't sufficiently detailed, so Touchstone, the employer, resorted to an internet search to find out more about the candidate. This revealed that he had been dismissed from a university course after expressing religious views on Facebook disapproving of homosexual acts. The charity therefore withdrew the conditional job offer, and the individual was subsequently successful in a direct discrimination claim on the grounds of his religious beliefs. The job offer was withdrawn because of his religious beliefs, which amounts to direct discrimination. If an organisation carries out a search of all candidates and only some progress through the next stage in the recruitment process, those unsuccessful candidates could find out by way of a subject access request or disclosure request that the organisation searched their social media profiles. Unsuccessful candidates could allege that the decision not to progress with their application was in fact based on a protected characteristic, such as their religion or belief or their sexual orientation, and therefore they could issue a discrimination claim despite them not being an employee. In order to successfully defend such a claim, the employer would then need to provide evidence of that not being the case. Using social media in recruitment also has the risk of unconscious bias playing a part in decision making and decisions being made on information which hasn't been verified or that could be taken out of context. Therefore, if you're going to use social media in recruitment, you should consider the following. Firstly, have very clear reasons and rationale documented as to why your organisation is using social media in your recruitment processes. These reasons, it's really important that you think these through in line with what we're going to discuss today in terms of justification, and document those reasons. As an organisation, discuss the benefits and the risks and consider how you might mitigate any risks. You could also seek legal advice on this. Secondly, use the use of social media consistently in your processes. Apply the same in every process and to every candidate. Document what the search uncovered that is relevant to the role being applied for, if anything. Don't make decisions based on anything that isn't relevant to the candidate's suitability for the role. That's the focus here. What you're looking for should be something to do with, are they suitable for the job in question? You could also use it to verify information that's claimed on an application. Similarly, if your search discovers something which on the face of it is unsavoury or problematic, consider questioning the candidate about it before making any decisions about the job offer. Consider when you use social media or a social media check. For example, instead of searching for all candidates right at the outset on social media profiles, maybe before making an offer to the best suited candidate that you've identified, do a check at that stage. And again, though this wouldn't be without its risks outlined on the slide before, because if you don't make an offer or withdraw an offer after what you've found, you're arguably limiting the number of people who are potentially open to bringing such a claim. So we've identified that a risk of using social media in recruitment can also pose privacy risks, and Hannah, who's a data protection expert, is going to comment further on this now.
Thank you, Laura. So I'm very much going to be looking at the use of social media within recruitment from the perspective of data protection and privacy. So as Laura mentioned, I sit within our data protection team, which means I can hopefully help to give some pointers as to how to use social media screening within your recruitment process in a way that complies with UK data protection legislation. Now, the starting point is that just because a candidate has made information available publicly on their social media profiles, that doesn't mean that it's appropriate for a prospective employer to search for it and consider it as part of the recruitment process. And really, this comes down to reasonable expectations. So when an individual first posted that information on their social media profile, they probably weren't envisaging that a prospective employer would look at it and take it into account. And ultimately, screening social media profiles, it is invasive and it's intrusive. So employers need to tread carefully when doing it and need to be able to really justify why it's necessary. Now, hopefully the ICO, which is the UK's privacy regulator, they've published some guidance which explains when it is appropriate to use social media as part of the recruitment process. Now, this guidance is under review at the moment, and that's part of a much wider project that the ICO is carrying out, really scrutinising and looking at data protection within the recruitment process. A lot of that project is focused around the use of AI, and obviously we're seeing an increase in AI tools used as part of the recruitment process. But what that means is their guidance around use of social media is also technically under review. But the draft updated guidance that they've shared doesn't deviate from what they'd previously published. And so we're not envisaging that there are going to be any changes to the rules or the requirements in this space. So if I then talk you through what those rules are, so on the next slide, I have set out the different lawful bases that are available. And when you're carrying out any data processing activity, and social media screening would be a data processing activity, when you're carrying that out, you need to have identified that you have a lawful basis for it. If you don't have a lawful basis, then under the UK GDPR, you're not able to carry out that activity. So as I say, the 6 available lawful bases under the UK GDPR are listed on the slide there. I've popped them all on the slide just as a helpful refresher of what they are and sort of which list to be working through. But ultimately here, in the context of social media screening, there's only going to be a couple that we'd be wanting to think about. If we look at consent to start with, the reason this isn't going to be appropriate is because of the imbalance in bargaining power between prospective employer on one hand and job applicant on the other. And that's because a job applicant is going to want to consent to the social media screening in order to obtain the job. So if the prospective employer asks them if they consent to this, they're incentivized to say yes, which means that that consent isn't freely given and it's not valid. So that automatically rules out consent as an option. And what this means is legitimate interest is going to be the lawful basis, which is of the most interest here. And that's one that we would then need to consider in the specific circumstances to see whether it justifies the use of social media screening. So on the next slide, what I've done is I've set out the 3-part test that we need to walk through when deciding whether there is a legitimate interest for carrying out social media screening. Now, the first part of the test is assessing, is there a legitimate interest? So what is the purpose of the social media screening? Can we identify a legitimate reason for needing to do it? If we can satisfy that first limb, we say, yes, we absolutely can. We then move on to part 2. And under part 2, we are then assessing, is the social media screening necessary for that legitimate interest? So if we've got a legitimate interest or a purpose for the social media screening, but actually there's less invasive means of obtaining the information, then ultimately we're going to fall down on limb 2 because we need to follow that less invasive route. But if actually we decide, do you know what, social media screening is the only way we're going to obtain this information or verify this information about the individual, then we can satisfy ourselves that that processing is necessary. That then brings us on to the third part of the test, which is the balancing test. So with the balancing test, on one hand, you consider what's the risk and the impact on the individual, and on the other hand, you weigh up your legitimate interest. And if your legitimate interest outweighs any risk to their rights and freedoms, you can proceed with the processing. If, when you carry out that balancing test, actually the risk to their rights and freedoms outweighs your interests, then you have to say, look, here the balancing test hasn't been met and we don't have a legitimate interest. So it's probably helpful for me to quickly walk through that 3-part test with a real life example in the context of recruitment. So if we look at a job role such as maybe a care worker or somebody within education who's working with teenagers. And the reason I've sort of selected teenagers for the example is because this is a group of people who we would expect to be on social media. So we know that actually if this candidate that's applying for the job role ends up working with these teenagers could go and find their social media profile, they could come across it, and there is, a chance that that could happen. So that's why as an organisation, we might decide, look, it is in our interest to assess this. And clearly in that role, the public persona of this individual is very important and it's very relevant. So for that worked example, we would be able to show that there is a legitimate interest in looking at their public persona on social media. Part 2 then, so is the processing necessary? Now, yes, quite clearly, screening public-facing social media accounts is necessary to assess someone's public persona. So again, number 2 is fulfilled. The balancing test then, and this is where it's not necessarily clear-cut or straightforward, in that we have to consider that there is a risk to the rights and freedoms of the applicant here, because actually if we carry out social media searches and what we find results in us not offering them the job, clearly they've been impacted by our social media screening, and that's very much something that we need to be considering as part of this risk assessment. But on balance here, the reason that we're carrying out this social media screening is to protect teenagers, potentially vulnerable teenagers, to protect the credibility and the reputation of the organisation. And on balance, those interests would outweigh the impact on the individual as a result of the social media screening. So that's a sort of a worked example, I guess, where we can clearly show social media screening would be appropriate. And there are other examples that we would potentially work through where it wouldn't have the same conclusion. But I think the main takeaway is it's only going to be appropriate to carry out social media screening where you can identify a very specific need or risk that you're addressing by doing that. And even then, you've got to make sure that you're balancing that interest against what that impact is going to be on the individual. So, assuming you have completed your legitimate interest impact assessment, you're comfortable that you can go ahead with the social media screening because you've got a lawful basis. There are then some final points to be thinking about under UK data protection law. So the first one is transparency. So the job applicant needs to know that you're going to carry out the social media screening. It can't be covert. So what this means is, as part of the job advert, as part of the application process, it's brought to their attention. And this means that they can make an informed decision about whether they want to apply for that job, knowing that it will result in their social media being screened. And as part of that transparency, recruitment privacy notices would need to be updated to be really clear about the circumstances when social media screening will be used or will take place, and also, which social media sites will be screened, what sort of things you're looking for, that level of information. So if we then take the second point on the side, which is division of recruitment teams. Now, staff members who are carrying out social media screening shouldn't also be the ones that make the recruitment decision. And the reason we need to avoid this is because if somebody is carrying out social media screening, that's likely to reveal irrelevant personal information that shouldn't be taken into account as part of the recruitment process, but which they're then subconsciously aware of, and it would ultimately impact any decision that they made, whether or not they'd like to think they've separated themselves from that. Ultimately, that information is then known to them. So the way that you get around this is you can designate one member of staff or maybe a small team who are going to be tasked with the social media screening, and they'll have a set criteria or a set list of triggers or red flags which they're screening against. Once they've carried out the screening, they will then pass on only the relevant information to the recruitment panel. So it may be in the majority of cases that they simply confirm we've carried out social media screening and it's come back clear. Or it may be that they don't need to notify anything at all because nothing came up on that social media search. But when something has been flagged, they can then pass on just that relevant flagged information. And then the recruitment panel have got the opportunity to put that information to the applicant so that the applicant can explain that or query it. And that brings me on nicely to the third point on the slide, which is making sure that where you've identified information as part of social media screening, you are giving the individual an opportunity to challenge that. And this can be done either as part of the interview process, if you carried out social media screening at an earlier stage of the recruitment process, or if, as Laura suggested, you're carrying out your social media screening as a final stage. So you've gone through the interview process and you're just at the point of deciding whether or not to offer to somebody. Pre-offer, you might do a social media screening check on that individual. And if actually it does flag up something relevant, at that stage, you would raise it with them, give them an opportunity to explain it or to question it, challenge it. And the reason this is really important is because often there's context behind things. Also, sometimes the information that's available online isn't necessarily accurate, and the individual might be able to plausibly explain it, and they should always be given the opportunity to do so. So the final point on the slide then is looking at the conclusion of that recruitment process or that recruitment journey. So whatever the outcome, whether or not you've decided to offer the job, you then have some information available to you or on file that has been picked up as a result of the social media screening. And it's really important that this is securely and permanently destroyed once that recruitment process has concluded. It is sensible to keep a record of the outcome of the recruitment decision, but the actual kind of information screened from their profiles should be erased. And this is to ensure that you're compliant with the GDPR principles of data minimization and not holding data for any longer than you need it. Now, ultimately, the burden will be on the recruiting organisation to demonstrate that any social media screening complies with data protection laws. So employers really do need to scrutinise whether social media screening is necessary in the context of the job role. And if it is, make sure that you're putting in place proper processes to ensure that it's used fairly and transparently. I'm now going to hand back over to Laura, who's going to have a look at the use of social media within employment itself.
Thanks, Hannah. So we've looked at social media in the recruitment process, but we're also quite often asked to advise on disciplinary cases or grievances which involve an element of social media in some way. So to finish off today, I'm therefore going to talk a bit more about this. We've advised on a number of cases where either a disciplinary process or a grievance process has had a social media element. That might include where social media posts are posted out of working hours, but they relate to employment, such as making negative comments about work colleagues or the organisation, where there's been offensive content just generally posted. We've also advised on there being bullying or harassment issues between colleagues, which are on social media, but technically outside of the working environment. And in some cases, social media can even provide evidence in disciplinary proceedings. However, with all these things, we need to bear in mind what Hannah said about processing information and making sure that you're complying with your data protection obligations. So often employers will want to take action if they find out that an employee has posted something offensive on social media. It's likely that in all cases, some investigation should take place in those circumstances, but the appropriate action will depend on the specific facts of the case and what's been posted and all of the circumstances and the context around it. The slide here mentions the case of Higgs, and the outcome of that case is, again, fact specific, but the focus was on proportionality and whether the decision to dismiss the individual in that case go too far. The court found that it did and held that the dismissal, which was as a result of a social media post, was unfair. The court specifically commented on the reputational damage, which it found was speculative. There was no evidence of the damage. So despite the employer saying you could have damaged our reputation by posting what you did, there wasn't actually any evidence of damage being caused. The post was made in the individual's maiden name, and it was only brought to the school's attention by one parent. We go into lots more detail about that case specifically on our HR Spring Clean webinar, which is available on our website. So if that's of interest to you, I'd recommend you go on our website and listen to that, because it delves into the case much deeper. But I wanted to raise it here because it's relevant to mention on the social media aspect. And the takeaway point is that you need to very, very carefully balance cases that involve reputational risk or potential risk, as the fairness of each decision certainly will depend on the facts in the case. Now, that case doesn't give all employees the right to post whatever they like if there has been absolutely no evidence of damage. That's not the case. But employers certainly should still take action and investigate anything which is offensive or discriminatory. So here we've suggested some questions and considerations you should take into account in any disciplinary or grievance processes where social media is involved. which will help you balance those competing elements and ultimately hopefully make a decision that's justified and fair in the eyes of the tribunal. So consider what exactly has been said. Who could this impact, or who has it impacted? Is the post linked to the workplace? And if so, how? Document how it's linked. Is it linked explicitly? Is it a direct comment about work or a comment that's posted on social media? Is it that it's an offensive post or some offensive content, and the profile page of that person lists their place of work and therefore links to the employer? Have colleagues, clients, or customers seen the post, and is there evidence of that? And if there is, document it. Or is it not linked at all? That person isn't linked to their place of work, but somehow it's been brought to your attention and you're aware of it. Is there evidence that the reputation of the employer or the organisation has been damaged or will be damaged? Is there a risk of impacting any conduct at work? So might people who have taken offence act in a certain way, or does the post or the content pose potential risks in terms of the behaviour of that person who's posted it in the workplace? Consider whether there have been any other concerns with the employee expressing either discriminatory views or similar behavioural concerns. If there's a pattern here, a pattern of behaviour, then that's something certainly to be investigated and something to be commented on in that investigation. Employee insights are really important as well. When you've raised this with the individual as part of your investigation, have they refused to remove the post? Can they not see what the issue is, or are they remorseful and understanding? And in terms of your investigations and internal processes, as always, there should be a fair and thorough investigation that takes place, an impartial decision maker appointed to make the ultimate decision. And it's really key, as we've said throughout this webinar, to document not just the decision, but how decisions were made, especially how competing rights have been balanced, both in terms of the data protection aspects and your employment processes. And taking into account these questions here should help you do that. So to summarise everything we've covered today, our top takeaway points are that a lot of risk can be mitigated by having clear policies and procedures in place, which clearly document the organisation's expectations when it comes to social media. Keeping clear records of the reasons behind decisions being made, such as in the recruitment process or in internal processes, is really important. And finally, not just having great policies in place, but keeping them up to date, communicating them, and training your employees on these issues would be our number one takeaway point. I hope you found that useful today. If anyone has any questions in terms of any of the content that we've covered today or anything else, employment, immigration, or data protection related, please don't hesitate to contact me or Hannah directly, and our contact details are on the screen. This webinar will also be made available online. It will be on our website, so please feel free to refer back to it and share it with your colleagues. But thank you all for attending today. We hope you have a lovely rest of your afternoon.